The Supreme Court has quashed a Gujarat government notification exempting factories from paying overtime wages to workers and providing ideal working conditions to them amid the COVID-19 lockdown. The court has also directed the government to pay overtime wages to workers for that period. The bench of Justices D.Y. Chandrachud, Indru Malhotra and K.M. Joseph ruled that the pandemic cannot be a reason to junk statutory provisions that ensure dignity and right to proper wages to workers. The order was passed in a petition challenging the state government's decision to exempt factories from the provision of Factories Act relating to work hours and other benefits. The bench has further noted that the statutory rights of workers could not have been set aside by the Gujarat government as the pandemic is not an internal emergency threatening the security of the country. While reading the verdict, Justice Chandrachud stated that the court is aware of the financial hardship faced by factories due to the slowdown in economic activities during the lockdown. However, the burden of economic slowdown cannot be put on workers alone, who are the backbone of economic activity, the court ruled. During the nationwide lockdown in April this year, the Gujarat government issued a notification exempting factories in the state from certain provision under the Factories Act between April 20th and July 19th. This notification was passed by the state in purported exercise of its power under Section 5 of the Act. The notification essentially exempted factories from the mandate to comply with the provision of the Factories Act, which deals with payment of overtime wages, working hours fixed for the workers, resting intervals, etc. The petition filed by the Gujarat Mazdoor Sabha and the Trade Union Centre of the India says, while granting this exemption to factories, the state government also did away with the requirement of payments of double wages for overtime and allowed for overtime hours to be compensated at normal working wages per hour. This notification was challenged on the ground that the state has acted ultra vires the Act, considering the fact that Section 5 only allows for exemption in cases of public emergency. The COVID-19 pandemic, while being a critical issue affecting the country, has still not been declared as an emergency. Therefore, the state government could not have exercised this power under Section 5 of the Factories Act. The plea filed through Advocate Arpana Bhatt stated, the provision under Section 5 allows for an exemption to be granted to factory or a class of factories. However, the notification under challenge has given a blanket exemption and is therefore liable to be quashed, the petitioner further contended. The court said, it is amply clear that the Gujarat government has misused Section 5 to suspend key provision of the Factories Act 1948, which offers basic and fundamental protections to workers, especially in time where workers are most vulnerable economically and socially. Bureau Report. We are now joined by Advocate Shivam Sharma. Shivam, please update us on today's court proceedings.
Yes, in this case, the court has said that the shocking extension of working hours is being directed at a time when the most basic medical and scientific advice to contracting the delay COVID-10 is to be rest and stay as healthy as possible. This new regime ensures the complete opposite as per the notification. This worker will now be overworked without being compensated for the same as per law, which will only ensure that both their physical and mental health deteriorate. The court further said that Section 5 empowers state government in case of a public emergency to grant exemption to any factory or class or description of factory from all or any of the periods of the Act, subject to a period not exceeding 3 months. In light of this observation, the court has quashed this notification.